Next year. Push it out to staff. They're good. Yeah. I agree. I mean, I think things you don't see, they may do one that else.
All right, well, thank you everybody for coming out today. My name is Michael Rolando. I'm an attorney with Biddinger, Schrot Rolando. I'm here to do a presentation on estate planning basics and the benefits of proper planning. So this is kind of an introductory kind of discussion. I'm not going to get into a lot of specifics or details. As a benefit of coming to this presentation, we do invite you to schedule an appointment with our office. And during that appointment, we would talk more about the specific aspects of your plan based on that scenario. So we're going to start with what is estate planning? So estate planning is planning for your estate. So what is your estate? Well, it's everything that you own and everything that you owe. When we talk about estate planning, there are two big areas that we cover. One is who can make decisions for you if you're not able to. That can be after you pass away or while you're still living. Let's say I get into a car accident or something like that. I'm not able to make my decisions while I'm living. I need to have some way where someone can have the legal ability to handle those decisions for me. So we're going to talk about that. We're also going to talk about what happens after I pass. How does my stuff go to who I want it to go to? All right, those are the two big areas of estate planning that we're going to cover. My grandfather always told me that if you fail to plan, you're planning to fail. So that is one big thing to remember and a big thing to take into consideration when you're thinking of, should I have an estate plan? Some of the key terms we're going to cover today are powers of attorney. So a power of attorney is a document that's in place while I'm living. It says while I'm living, if I'm not able to make my own financial decisions, then I want this person to do that for me. If I'm not able to make my own healthcare decisions, then I want this person to do that for me. There are two powers of attorneys, one for finances and one for healthcare. They cannot be combined in the same document. We're going to talk about a guardian and conservator. If I don't have a power of attorney in place, that's the other way to have someone make decisions for me while I'm here. A guardian and conservatorship have to go through the probate court. So if you want to avoid the probate court, then you don't want to rely just on that. And then we're going to talk about probate a little bit. So probate is one of the three branches of the court. It deals exclusively or pretty much with estates, people that are in jeopardy of being harmed, disabled people, older people, children, people that need protection. We are going to talk about ways to pass on your things to who you want them to go to. Those involve the trust, the will and testament. We have the executor and trustee. Those are people in charge of making sure things pass on after you pass away. Some of the other things we're going to talk about involves estate taxes, gift taxes. So the estate tax, a lot of people think of it as an inheritance tax. People say, well, what's my inheritance tax? Well, there's kind of two things to go with that. There's a state tax for the state. Each state may have their own estate tax, and then there's a federal estate tax. Michigan does not have an estate tax for itself. So all we have to worry about is the federal estate tax. Right now, the federal estate tax is set at $13.99 million per person. It's going to increase to $15 million per person in 2026. What that means is if your estate is less than that $13.99 million when you pass away, you're not going to have to worry about an estate tax. That applies to most people. Not many people really have to worry about that. We also have a gift tax. So a gift tax is if I give something away, I may have to pay taxes on it. I can give away up to $19,000 a year to as many people as I want to, and I'm not going to have to pay taxes on that. If I gift more, then I have to file a gift tax return, and I'll find out if I have to pay taxes on that. And then we also have stepped up basis. Stepped up basis relates to real property, so houses, land, and it also can rely to certain investment accounts like brokerage accounts, stocks, and those kinds of things. What it means is if I inherit something, then I get what's called a stepped up basis. If I inherit a piece of property, when I inherit it, my value in it is considered the then fair market value. If my parents bought it for, $10,000 50 years ago, and now I inherit it and it's worth $50,000, that's my value. I don't have their same value. The benefit of that is if I turn around and sell it and I sell it at the fair market value that I inherited at, I don't have a capital gains tax. Whereas if they had sold it at $50,000 and they had $10,000 into it, then they would have a $40,000 capital gains tax. So that's the stepped up basis. So the next thing, or the big thing we're going to get into is no, there's not a cap on the step up in basis. Your parents or grandparents could have bought property, for $5, or maybe it got transferred to them and they inherit it. So they got it for zero value. When you inherit it from them, then you get the step up in basis to whatever it is. So it could go from $0 to $5 million and you get a step up in basis. It applies to certain properties, not everything. Certain real estate is one of those things. If you inherit it, you get a step up in basis, stocks and other things like that, but not necessarily IRAs or things of those sort. They don't really have a step up in basis, but okay. It's a good question though. So the first thing we're going to talk about are who can make decisions for you if you're not able to. We like to use powers of attorneys instead of going to the probate court. If you go to the probate court to set up a guardianship or conservatorship, then usually it's going to take more time, it's going to cost more money, and you're following the court's order of who can be in charge. If you do your own power of attorney, then you get to pick who's in charge. So maybe I don't want one of my children to be in charge of making my decisions because they're not great at spending money. Or maybe they wouldn't be able to make the healthcare decisions that I want them to make. So I'd rather have my sister or my friend make those decisions for me. If I'm going through probate court, my kids are going to have first priority. So unless they all agree to say, no, I want that job, then I'm not going to necessarily have my friend or my sister, brother, sibling be able to make those decisions for me. So in a lot of ways, it's better to have a power of attorney in place. There are two. There's one for healthcare and then there's one for finances. The financial power of attorney allows somebody to legally help you manage your bills, your expenses, your assets. They can help with banking, selling things, making sure that all of your investments are taken care of. A good financial power of attorney will list a primary person to handle those decisions for you. If you're married, in most cases, the first person on that list is going to be your spouse. And then we like to have one or two other backups just in case something happens to them, then this alternate person can step in. It's also going to have provisions about that person being able to help with estate planning. If you didn't set up your own plan and you pass or have some problem where you're not mentally capable or physically able to set up that plan now, then through a power of attorney, that person could help you set up that plan. It can also allow them to help with long-term care planning. You want to make sure that the power of attorney has specific provisions regarding gifting and other things that allow them to help with that long-term care planning if it becomes an issue. The healthcare power of attorney is very important too. It allows someone to make your medical decisions, allows them to talk with doctors. There's the HIPAA law, I'm sure you're all aware of it. It says that basically you're the only person that can talk to the doctors and hospitals about your medical information. A well-drafted healthcare power of attorney has a release saying that your agents can talk to those doctors and hospitals too, so they can make a fully informed decision. It allows them to assist with medical decisions while you're still capable. And then once you become completely incapacitated, they can make your medical decisions. It should also describe what kind of treatment you want in those conditions. So for example, if I go into a coma where the doctor says there's no reasonable likelihood that I'm going to come out of it, do I want to remain on life support or do I want to come off? The power of attorney should clearly state that.
Is it always the family member?
No, you can have, so if you do the power of attorney, you can have somebody who's not a family member. You can have the friend, you could have a sister, you can have anybody else that you want to, as long as they're 18 and you trust them to make those decisions. If you go to court for the guardianship and conservatorship, then you have to get through the order of priority, and it's going to start through family first. So that's another reason to avoid court and use the power of attorneys instead of the guardianship and conservatorship. All right. So what is probate court? Probate court is a branch of the court system. There are a couple of different courts. Probate deals exclusively with things like guardianship, conservatorship, estates, and things like that. It can be a tedious process. You have to pay extra fees, and then you have to follow their processes and their order of priority. A lot of people want to avoid probate for one reason or another. It can be expensive. It's invasive. They dig into your life. It's public. So anything that's in the court file, they can go in and look at. Anybody could go look at. And it can be a lot of extra stress on your family as they're going through a difficult time as you're not able to manage your own affairs or after you pass away. It can also cause Medicaid recovery, and we'll talk about that a little bit later. So how do we avoid probate? So now we're going to get into the ways that we can pass on our assets. One is through probate. If you have a basic will and testament, and that's your only piece of estate planning. A lot of people think, well, I have a will. A will is going to keep me out of probate, but that's not true. A will are instructions for what happens in probate. So I don't want to rely just on a will. I can have a will as part of my plan, but I don't want it to be the sole part of my plan if I'm trying to avoid probate. And we have a couple of different ways to avoid probate. There's two basic ways. One way we call our probate avoidance plan, where we're doing things like adding beneficiaries onto accounts, doing something called a ladybird deed, and then the other is through a trust. A trust is like a box that you put your property into, comes with a list of instructions saying that this is who my stuff goes to when I pass away. This is who's in charge of doing it. I can build in a lot of contingency plans. I can say if one of my beneficiaries passes before they get their full share, their share goes here instead. So maybe I have everything going equally to my kids, but one of my kids passes away before me. So I want their share to go to my grandkids, but I don't want my grandkids to get their full share until they turn 25 because I don't want an 18-year-old to just get it and blow through it. I can build it all into a trust. An irrevocable trust is a special kind of a trust that we use a lot when we talk about Medicaid planning, and we'll talk about that in a little bit. So what is our probate avoidance package? Well, we use a ladybird deed. A ladybird deed relates to real estate, your house, and the land that it's on. So the land and any buildings that are attached to it, but not the contents of those buildings or the contents of the house. What a ladybird deed says is I own the buildings and the land. I can do whatever I want with it during my lifetime. As long as I still own it when I pass away, then I want it to go to these people. And it automatically transfers to them on your death. They get the step up in basis because they're inheriting it, so you still get that benefit. You still get control and ownership while you're living. It doesn't transfer until you pass, so you don't have to ask them for permission to do things. So ladybird deed is very beneficial for that. But it also has to be the right situation. We don't want to do a ladybird deed in certain situations. If we have 4 kids and we want the property to go to them equally, but my kids don't get along and they're not going to be able to figure out what to do with that property when I pass away, I don't want to necessarily put them all on owners of the house because they're just going to get a headache. A trust in that situation would be a better situation or document or method to pass on the property. We're going to make sure we add beneficiary designations to all of our financial accounts, our bank accounts, our investments, our retirement. If we list beneficiaries on those, when I pass away, those go directly to those people instead of going through probate. We are going to do something called a deed of gift of personal property. So personal property are things in my house. I've got my firearms, my jewelry, clothes, furniture, my paintings, all that kind of stuff. That document says that after I pass away, all of that stuff goes to these people that I want it to without having to go through probate. And we also include powers of attorneys with that plan. Tell me my clicker didn't die.
Maybe completely different than ladybird.
So, no. When you look at a deed, you're going to a lot of times see that it's going to be titled either quitclaim deed or warranty deed, right? That just refers to what's being passed on. The actual language for the ladybird language is going to be in the actual body of the deed. It's not going to say ladybird deed at the top. If I do a quitclaim deed, I'm just telling you that I'm giving you whatever I have. I'm not guaranteeing that the title's perfect. A warranty deed is I'm warranting that the title is good. So if I give a warranty deed, I'm telling you there are no problems with the title for this property that I'm giving you. You won't see the title won't say Lady Bird deed, but the document of the deed will have language stating that I give this property to myself for my lifetime. I can do whatever not that exact language, but I can do what I want. If I still own it when I pass away, it goes to here. So a Lady Bird deed can be either a warranty deed or a quitclaim deed. A Lady Bird deed is a transfer or referred to as a transfer on death deed, meaning that title passes when I pass away. It goes outside of probate and it needs to be the right situation. For example, I don't want to make the 4 kids equal owners if they're not going to be able to get along. It's part of our probate avoidance package. The other method is a trust. So a trust, again, is that box that I put my property into, comes with the list of instructions. A trust can be good because it can help us provide for loved ones. If I have a disabled son and I want to make sure that they receive their share and it doesn't interfere with any government benefits that they're getting, then a trust is the right way to do that. I can set up my trust to say that that disabled son share would be funneled into a special needs trust for them. That special needs trust then can be managed and used in a way that doesn't interfere with their government benefits, but they can still get some benefit from their inheritance. I can provide for my beneficiaries. If I have a surviving spouse, I can make sure that everything is set up so that it provides for my spouse. I can make sure it provides for my other beneficiaries, my kids. If a child has spending problems, then I can set up the trust in a way that it restricts how much of their share they get at one time. So I can put those kinds of things into it. And it can allow me to protect assets. It passes outside of probate, so it avoids that Medicaid recovery if I ever need to use Medicaid to pay for that long-term care. And then there are different kinds of trusts you can set up, asset protection trust, Medicaid protection trust. That can be.
You back up and say the last thing you said one more time.
I would
Medicare.
Medicaid. Right. So there are, when we talk about Medicaid, we're going to talk about recovery, which means that if I use Medicaid to pay for my long-term care, when I pass away, Medicaid becomes a creditor against my estate. So I can avoid things going to my estate by things avoiding probate, right? A trust is designed to avoid probate. The Lady Bird deed package or the probate avoidance package are designed to avoid probate. So a trust can help with that problem. It can protect my assets from being sold and paid back Medicaid when I pass away. Yeah. One of the big things with the trust, I can create a trust. I can have all the great language in it saying that my stuff goes to these people. My special needs child is protected. My child that doesn't know how to spend things well is protected. My spouse is protected. But if I don't fund it, all that trust is a bunch of paper. Funding is a process where I'm making sure assets are titled, that they're beneficiaried in a way that they go through the plan. If I don't do this, then everything's going to have to start in probate anyway. So when I'm talking about funding, we're talking about all of your assets. So it's your real estate, your home, your mutual funds, personal assets, any types of investments, retirement accounts, and all of that. So when you set up an estate plan, it also involves setting up a plan for how everything is titled and beneficiaried so it goes through the plan. A big difference between the probate avoidance package and a trust is what happens when you pass away. With the probate avoidance package, with the Lady Bird deed, for example, as soon as I pass away, these beneficiaries become the owner. It's an automatic transfer, pretty quick. With the beneficiary designations on my accounts, when I pass away, they can reach out to those companies, provide a copy of a death certificate, and those companies will start working with them to transfer over their payments. That can usually be completed in a month or so. So it can be pretty quick. With a trust, it's a lot longer. So a trust has different steps that are supposed to happen when you pass away. While you're living, a trust is basically an extension of your Social Security number. When you pass away, your Social Security number goes away. So the trust has to set up its own tax identification number. It freezes for a minute and it has to unlock. So the trust has this period where the person who's in charge of it isn't going to be able to do anything for a second. They have to unlock it again. And then once that happens, they have to start going through the steps. One of the first big steps is there's this 4-month waiting period of sorts. they have to put a notice in the paper to creditors telling that they have a chance to put a claim in against the trust. During that 4 months, while you're waiting for the creditors to put their claim in, you can make sure everything is taken care of. If assets are going to be sold, you can sell them. You're going to be pulling all the assets into the trust, getting ready to deal with the creditors at the end of the 4 months and then distribute. But usually there's a 4 to 6 month period where nobody's going to receive anything from the trust. So a lot of people don't necessarily like that. But there are the other benefits to the trust. I can build in the contingency plans that I can't build into the probate avoidance plan. But that is one of the big differences between a trust and the probate avoidance plan. Another issue we talk about is how does long-term care planning affect all of this, right? Long-term care involves a couple different things. It involves a few stages. So if I start out first, I'm able to stay in my home. I don't need any help taking care of my stuff. That's the basic stage. The basic stage we hope we all can stay in until we pass away. But maybe I get to the point where I'm not able to take care of everything for myself. And then I'm going to have a friend or a neighbor or a family member, somebody that can come in and help me at my house a couple of times. And maybe I want to pay that person for that help. If I'm going to pay that person for the help, I want to make sure I have something called a care contract set up first. A care contract is a document where my doctor says, I need this care from this person to be able to stay in my home and not have to go into a nursing home. If I don't set up their care contract before I start paying someone to come into my house and help me, then I am going to have Medicaid issues in the future. And we'll talk about those. Medicaid counts as a gift. So when we talk about the Medicaid gifting issues, we'll understand why that's a problem. Maybe I get to the point where I can't stay in my home even with that help. Then I'm looking at either a nursing home or assisted living. If I can go to an assisted living facility, that's going to be less expensive as a nursing home. But it's going to typically, in most cases, be an out-of-pocket expense. It's going to cost me between $4,000 and $8,000 a month for that. If I get to the point where even that isn't enough, then I need to go to a nursing home. That's what we're going to focus on with this long-term care discussion. So there are 5 ways to pay for that nursing home, that long-term care. One is out of pocket. Out of pocket's going to cost me $10,000 to $15,000 a month per person. A second way is through long-term care insurance. If I have long-term care insurance, that may help cover all or some of my costs. If you don't have long-term care insurance, then I always suggest checking to see if you want it or qualify for it. You can talk to your financial advisor. It's not necessarily going to be appropriate for everybody. Sometimes the cost is going to be too much. It can be very expensive, $10,000 or more per year, depending on your health situation and your age. So make sure you take that into factor. Veterans aid and attendance benefits. If you are a veteran, depending on when you served and your level of disability, the VA may help cover some or all of your long-term care costs. If that is your situation, then I suggest that you talk to your VA rep to see if that's something they would help you with. And then we have Medicare. Medicare is a health insurance for people 65 years and older. Medicare says that if I spend 3 days in the hospital, I transition from there into the nursing home. Medicare will cover at least the first 20 days of that nursing home care and maybe up to the first 100 days. How much you eventually get really depends on the type of Medicare policy you have and how you're progressing through rehab while you're in the nursing home. And if none of those other options are available, then you're looking at Medicaid. Medicaid is what we call the payer of last resort. It's kind of the last option that we have. So Medicaid is a giant government program. They have a lot of sub-programs that help with different things, and one of those helps with long-term care nursing home costs. Medicaid, though, has a few issues with it, and we're going to talk about those. One, you have to be able to qualify for it. Medicaid has a couple of tests that you need to make. You have to be at least 65 years or older, and you have to meet their asset test. So their asset test, when you apply for Medicaid, you basically have to prove that I'm a person that can't help myself. I don't have the funds or assets to be able to help myself, because that's what Medicaid is set up to be, and a program that helps people that can't help themselves. So what they do is Medicaid, when you apply, they look at all of your assets. If you're a married couple, they look at everything that you own, your spouse owns. Doesn't matter whose name it's in, they look at all of it. They lump it all into 2 piles. One pile is exempt assets. These are things that they can't account against you. They can't make you sell these things for you to be qualified for Medicare or Medicaid. One of those assets is your home. So your home, your primary residence, the land that it's on, that's protected. If I have my house on a 40-acre parcel and I have a parcel, another 40-acre parcel across the street, that's called contiguous. So that's considered part of my home. So it can be protected as long as there's not another residence on the other parcel. If I have another parcel down the road that's not touching my home, that's not protected. So that's going to go in the other pile of what we call countable assets. But my home is one asset that's protected. If I'm married, I can have an unlimited value in that home. So I can have a $5 million home and I'm married and they're not going to count it against me for Medicaid purposes. When I become single, though, I'm capped at $730,000 of equity in that home. So I'm no longer protected over that amount. My personal property, so the stuff in my house, that's protected. They can't count that against me. Right now, farmers can kind of get away with a lot right now because they count tractors and equipment as personal property. We've been waiting for that to change, but right now it's still that way. Prepaid burial plots. You can each have a prepaid burial plot and those don't count against you for Medicaid qualification. You can have one car. A car counts as anything with a vehicle or registration or title. So if I have a car, my spouse has a car, I've got my travel trailer, I've got my four-wheeler, my motorcycle, one of those is protected. One per couple, not one per person. So one is protected, everything else goes in your countable pile. I have certain life insurance policies. Term life insurance policies have no cash value, so those are protected. Cash, whole life insurance policies with a value of $1,500 or less are protected. All of my other life insurance policies count against me. The way that works out in reality is that pretty much all of your whole life insurance policies count against you. And then we have our countable pile. So that's everything else. So any extra real estate, any extra vehicles, all of my bank accounts, all of my investments, all of my retirements, all that stuff. So what Medicaid says is they look at that countable pile when you apply. When you apply, they look at the countable pile, they add it all up. If you're married, they cut it in half and half goes to each spouse. Spouse going into care has to get their half down to about $9,600. Spouse who's staying out of care has to get their half down to somewhere around $150,000. So people hear that and they think, well, I'm never going to qualify for Medicaid. I have too much stuff. Well, that's not necessarily true. There are a couple of things that you can do to plan ahead to qualify for Medicaid. One of those, some people think, well, can I just give stuff away? You can, but that comes with another problem with Medicaid. Medicaid has what's called a 5-year look back. So when you apply for Medicaid, from that day, they look back 5 years in your life history to see if you've given anything away. They add all those things up. So if I've given my kids, I still have that gift tax exemption. So I've been giving my kids $19,000 a year. Let's say, for example, I have 5 kids. That's going to be roughly $100,000 a year. Added up over 5 years, that's a lot of money. If I give those things away, it still counts against me for Medicaid, even though it doesn't count against me for gift tax purposes. The problem with this is they add up all those gifts in that 5-year period. They say for approximately every $10,000 worth of gift you've given away, it creates a 1-month penalty. That means you're either going to have to fix all of those gifts, get all of the money and all the things you gave away back, or you're going to have to pay for each of those months you have a penalty. So for example, if I have $100,000 worth of gifts, that's approximately 10 months of penalty. I'm either going to have to pay for 10 months of long-term nursing home care before the government's going to help me, or I have to get all that $100,000 back. So we don't want to just give things away. So is there a way we can legally protect assets and otherwise qualify for Medicaid? There are a couple of ways. One is we use something called a Medicaid Protection Trust. So remember, we talked about the trust is the box with the list of instructions saying that this is who my stuff goes to. The normal type of trust is a revocable living trust. So you're in complete control of it. It really doesn't change your ability to do with anything you want with your assets. You can make any changes to it. A Medicaid Protection Trust is different. It's the same concept. We have the box with a list of instructions. However, this time you're putting a lid on the box, you're locking it, and you're giving the box and key away to somebody else. You're no longer in control of what's in that box. So you don't have free access to it. You're restricting your ability to use it. You can't take that stuff out of the box and use it again. If it generates income, you can get the income, but you're not in control of that box. If you do that, Medicaid says, okay, that stuff you've given up access and control, so we're not going to count that as your stuff anymore. So we're not going to put in your countable asset pile. The problem is that counts as a gift. So anything that you put in the trust, 5 years after you put it in, it would be protected from Medicaid because you've made it outside that 5-year look back period. That's one way to protect things from Medicaid. Another way to protect things from Medicaid is what we call crisis planning. So crisis planning is means I'm on the doorstep of going into the nursing home. What can I do now? So let's say, for example, I fell and broke my hip. I'm in the hospital. The hospital's worked and done what they could for me. They've sent me to rehab in the nursing home. Rehab's trying to get it so I can go home, but they're just not able to do it. They say I'm going to have to stay in the nursing home to get the type of care that I need. At that point is when you can do a crisis plan. There are things that you can do in a crisis plan that you can't do at any other time. And there are methods that we can use to save assets and get one person qualified for Medicaid. If you're a married couple, generally speaking, doesn't matter what your assets are, asset amount, but we can one person qualified for Medicaid and saved the majority of, if not all of the assets for the other spouse, so that they have something to live off while the other person's in the nursing home. If you're a single person, we can still do things through the crisis planning, but typically we're saving between 50 and 70% of assets. The last aspect of Medicaid that we're going to talk about is recovery. So recovery was a program that was started in 2011 when Michigan was kind of forced into doing it. Before that, they fought the federal government as much as they could, but federal government said, if you don't start doing this, we're going to pull your Medicaid funding. So recovery basically says that if you use Medicaid for long-term care costs, when you pass away, they become a creditor against your estate. So anything that would have to go through the estate and through the probate court when you pass away will have to be sold to pay back Medicaid. That could include your house, vehicles, bank accounts, personal property, all of those things. So one thing you want to definitely make sure is set up a plan that avoids going through probate. You can do that through our probate avoidance package or a trust. So that is the basis of our presentation for today. I just want to stress that it definitely makes it's better to get your plan set up in place now because it can save you a lot of hassle and problems and costs in the future. It pays to take the time to do it right now instead of waiting in the future. If you don't set up an estate plan, it doesn't mean you don't have a plan. It's just you're following the government's plan. The government's plan may not be the same thing that you want, and the government's plan may be that all of your stuff is going to pay back the government for your care in the nursing home when you pass away. So we want to thank everybody for coming today. I do take questions, so if you had questions, I'll take them. I don't necessarily want to get into specific questions about your specific scenario today. That would be something better for an in-house conversation with an attorney from our office. But yes, I saw your hand.
Yes, I have a question from the Zoom. They are questioning the gift tax at the beginning. Is the gift tax 19,000 per person or a one-time per year?
Well, so 19,000 per person per year. I can give away $19,000 to all of my kids. If I have 5 kids, I can give them each $19,000, and I don't have to file a gift tax return for that. And then it resets at the end of the year. And usually that amount changes on a yearly basis. So for 2026, it would reset and I could gift another sum.
So annually, you're saying you can go that way?
Correct. And you can give that much away to more than one person. Any other questions?
What's the approximate cost to do a trust?
If we're looking at, from our office, if we're looking at a general revocable living trust, if you're a single person, it's going to be around $3,500. If you're married, it's going to be around $4,000. If we're looking at more the Medicaid protection trust, it's a little bit more expensive, but it really just depends on the scenario. And when you sit down with an attorney from our office, we give you a quote. stating that this is the plan we think would work for you. We talk you through it, and then we'd say this is the cost for that plan.
This initial consultation.
Well, you get a free consult for coming to this presentation, so you don't, right. So you don't have to worry about that, right? Just call our office, say you came to this presentation and you get a free consultation. Yeah.
You talk about the different packages. Now, if I was to go through you and get my estate all plan and everything, is there a cost for each individual package?
So we wouldn't necessarily have you both do both a Ladybird deed package and a trust. We say we think this is what you should follow along with, and then you'd be quoted the cost for that. If you wanted, you don't necessarily need to set up both the probate avoidance package and a trust. You can choose one or the other. Either one will complete the same thing for you. So you're not necessarily going to be charged for both. If you wanted to do both, then yes, you'd be charged for both. But yes.
If you own two homes and you have one in like a Ladybird need, but you need to go into long-term care, so that second home will be up for grabs from Medicaid.
Right, that goes in the accountable asset pile. So that would be something that they could potentially force you to sell ahead of time. If you had set up the Medicaid protection trust ahead of time and put that second home into it and 5 years passed, then it could be protected. But otherwise it would count as an asset and you potentially have to sell it.
All right, so they would also like to know if you then yearly review your plan and what would the approximate yearly cost be?
So we don't necessarily review them every year. We recommend reviews every 3 to 5 years or when there's a major life event. The cost varies depending on if they're making any changes. We do have something we call client care plan where people can purchase into and then they'll get free yearly or yearly reviews come along with that. If that's something that the person's interested in, they can talk to us at the consultation and we give them a quote for that. But if we're making changes in 5 years, it really depends on what we're changing for what that cost is going to be. Yes.
Do you have local offices?
We have an office in Sandusky right across the street from the courthouse.
Or
Yeah. We do.
it-
Yes. Any other questions? We have actually 5 offices. So we have one in Sandusky, we have one in Bad Axe, one in Cass City, one in Carroll, and then a satellite office in Reese. But the closest one to here is going to be right there. Okay. It looks like there's no more questions. All right. Well, I want to thank everybody for coming out today. You've got your packets, you have our information. So if you'd like to set up an appointment, please give us a call. You're welcome.